Hey everybody, I'm Taylor Jefferson. I'm the principal broker of Jefferson Real Estate here in Richmond, Virginia. Now there are lots of forms and documents that you'll sign when you're putting an offer in on a home or if you're accepting an offer on your current home. The most important one is the Central Virginia Regional Purchase Agreement, and that's what I'm going to go over in this video today. After watching it, you'll be prepared and understand exactly what you're signing before you sign it, which is important. So let's just jump right in. The very top of the contract includes the date of the contract being written and all the parties involved, the buyer, the seller, the listing broker, the selling broker. Right below that, section 1 simply states the home address that you plan to buy. Now, there's a part of it as the legal description and the tax ID number, but there's also the more common, the street address, 123 Main Street. Section 2 is where you put any personal property that you wish to have convey with the purchase of the home. This is where you'll add in things like the kitchen fridge, a garage fridge, the washer, dryer, anything else specific that you might want. It also states what's automatically included, so be sure to read that. If there's any question, ask your agent. Section 3 is just where you call out any other special attachments to travel with this contract, such as a lead-based paint disclosure or the as-is addendum. I'll do more on those forms in a later video. Section 4 is all about financing and price. The price of the home will be spelled out in words and in numbers, and then below it'll state if you plan on paying cash or getting a loan. If you're getting a loan, it'll say what type of loan, conventional, FHA, VA, and what % down payment you want to put down. And at the bottom of the page for section 4, there's a spot with how much closing costs you want to ask the seller to pay for, so pay attention to that. Section 5 states whether the purchase of the house is contingent on the home value appraising. This section also spells out what happens if the home doesn't appraise, meaning the appraiser says it's not worth as much as you offered to pay. Section 6 just simply states, if you're applying for a loan, you have to do so within 7 days of ratification. Number 7, section 7, is a statement just reminding you, hey, wire fraud is real, it exists. Be careful, always confirm with who you're sending money to before you send it. Section 8 is where you fill out how much you want to put down as your earnest money deposit, also called EMD, and the time frame for which it's due, and who's going to be holding it, who's going to act as your escrow agent. It also explains what happens in the event of a default, meaning somebody breaks the contract, who's entitled to that money. So be sure to read that. Section 9 just states where settlement will occur, so who's the closing attorney, who's the closing agent, and when, the date that you want to close. 10 is whether you plan on occupying or not. Is it a primary or secondary residence, like a vacation home, or is it an investment property? Is it a rental? And so you click whichever one applies. 11 is the residential property disclosure paragraph. It states whether that residential property disclosure is required, and if it is attached along with the contract. Most homes will require that disclosure, except for foreclosures and new construction. Number 12 is a fair housing statement, and if you feel discriminated against, tell somebody. So section 13 will be checked yes, if the home is in an HOA. And if it isn't an HOA, the seller is required to get the HOA to furnish a resale disclosure packet. What's important about that and important about this paragraph is you have a 3-day right of rescission as a buyer to walk away for any reason. Even if you love everything in the HOA but you just changed your mind, you can back out once you receive that the resale disclosure. Section 14 is just like the HOA paragraph, but for condos. So a condo resale packet disclosure will be generated by the seller. So section 15 states that when the property is in an HOA, the resale disclosure packet will also generate a compliance form, meaning is the house up to the standards of the HOA? Is it in violation of any rules? If it's in violation of any rules, you have 5 days as a buyer to request them to repair, fix, bring it back up to the standards of the HOA. And if they don't do that, you can back out. And 16, section 16 is huge. This is all about the home inspection. It states when you must perform an inspection by and submit your repair request to the seller. It also spells what you can ask for and what you can't. What qualifies as a defect versus what's just an old system, what's antiquated, what's a cosmetic defect. And then towards the bottom, there's an optional paragraph. When that paragraph is checked, it means that you can back out if you're unsatisfied with the home inspection results. Now, word of caution here. A lot of sellers will not accept that if it's checked. They won't sign off on that contract because they at least want the chance to fix it. They don't want to think that you can just back out if you change your mind. So very few sellers agree to that. Just be aware. Section 17 talks about default, meaning if you break a part of this agreement, if you don't do what you say you're going to do per this agreement, and that there can be consequences. So it's best to talk to your agent first, and if you need legal advice, to seek it. Section 18 is a reminder that you have a choice in your settlement agent. No one can tell you who to use. You can pick whoever you want. Section 19 states that a seller authorizes the settlement agent to disperse brokerage fees as set forth in the agreement between the seller and the listing broker. Section 20 is where you put if you want to obtain a home warranty. And if you do you want to ask the seller to pay for it? And if you do, how much do you want them to cover? Because there's varying cost. Maybe they cover $500, but it costs $650. Well, you as a buyer will have to cover the difference. Or if you just don't want a home warranty at all, you can put that there too. Section 21 is a reminder that the brokers might be involved in other related business and services. And if your broker's involved in other related businesses, you're probably going to be signing another form stating, hey, I also own a part of this mortgage company. I also own a part of this home insurance company, FYI. So you'll probably already be aware of that, but that's just a reminder in this contract. So Section 22 is important. It was put in there to make sure that people weren't being shady, that buyers weren't not disclosing they have to sell their house in order to qualify for the one they're trying to buy. And so this section states that the purchaser does not have any property, real or personal, real property being real estate, personal property like a car or truck, something like that, they have to sell in order to buy this house, except as disclosed in this contract. So you can put in there, hey, I need to sell my home at 123 Main Street in order to purchase this home. It's currently under contract and scheduled to close then. That's a contingent offer. So Section 22 is just reminding you as a buyer, you can't hide that fact. If you have to sell something in order to buy your next home, you must disclose it in the contract. Section 23 is a blank section to put in additional terms, such as if you're contingent on another home sale, or maybe an escalation clause, or waiving a certain amount of the inspection, or the fireplace, chimney, and flues convey as is. This is where we can fill in the blank and add in whatever we might need to add in situation dependent. So Section 24 is quite lengthy. It's got 12 subsections to it, and it just goes over some standard provisions and general rules of the contract. So 24A talks about expenses. The seller's to pay for customary seller expenses, the buyer's to pay for customary buyer expenses, and everything else in the middle will be prorated based upon the day of closing, meaning it'll be split based upon when closing is. Section 24B, the title will be conveyed to the purchaser free and clear, and then it goes on to talk about if the property doesn't have access to a road or abuts to a road, that an easement will be created and conveyed to the purchaser in order for them to access that property. So Section 24C talks about the land use assessment. And land use is when the local government grants a lower tax bill based upon the current use of the land, i.e. farming. Now, if the sale of the property bumps the property out of the land use agreement, there can be back taxes that are owed. And so this talks about who's responsible. Be sure to ask your agent if you think that's the case, or just ask them, hey, does land use apply here? It's a good question to have because it can be an expensive mistake. 24D explains that the risk of loss is on the seller until settlement. So if something catastrophic happens, it's on the seller to fix. Now, as a purchaser, let's say a tree falls on the house prior to settlement. You can back out, or you can let the seller fix it and close, or you can let the seller's insurance provide all the policies and remedies in place and you can still close, but you have the option. 24E, it talks about delivery of the property. It must be delivered in the same condition as the time of contract, so all the systems must be working. If something breaks in between contract and settlement, the seller has to fix it, bring it up to the same condition at time of contract. They also have to leave it in a broomed, swept condition. The 24F, that notes whether the property is on well and septic, or if it's on municipal water and sewer, or any combination thereof. If it's on a well, the seller will have to pay for a well water test, and if it's on septic, the seller will have to pay for a septic system test, as well as possibly pump the contents based upon what's put in the contract. 24G, similar to that, is the termite inspection, and the seller also has to provide a termite inspection, and it has to be dated 30 days prior or less to closing, meaning it's current. Now 24H talks about what happens when the well water, the septic, or the termite inspection is bad. Maybe there's repairs that have to be done or treatments that have to happen. The seller's obligated to perform the repairs up to a certain monetary limit. If no number is put in 24H, that limit is $1,000. Now it can also be higher. You can put in whatever you need to put in there. Now, what happens if the repairs exceed that limit? The purchaser can walk away, or the purchaser can accept whatever the seller's obligated amount is. 24I, this is just an extra level of protection for FHA and VA loan home buyers. The purchaser is not obligated to purchase the property when using those loans if the appraisal does not come in at or above the purchase price of the home. So if it doesn't appraise, they don't have to buy it and they can walk away. 24J is the seller acknowledges that there are no mechanics liens on the home, and if any work has been performed on the property within the past 90 days, that they will sign an affidavit stating all work and materials have been paid for. Because you don't want to inherit a house that has a mechanics lien on it. And a mechanics lien is placed by a contractor who either has not been paid for work performed or for materials performed doing the work. So that's why it's important for a seller to acknowledge and sign an affidavit stating everybody's been paid in full. So 24K talks about mediation, and in the event of a dispute between the buyer and seller, they're going to go to mediation before taking legal action. And if no agreement can be reached with mediation, then you may seek judicial action, but you're going to try mediation first. 24L is just miscellaneous rules about the contract, including added terms or assignment of the contract, and very important, the time frame calculation. So just FYI, when you're computing a time period, such as your home inspection time period, the first day is the day following the commencement of the time frame, so it's typically the day after ratification. So section 25, seller acknowledgement that all parties that are required to sign the agreement in order to sell the house have signed, and that everybody that has signed has an ownership interest in the property. So think of a scenario where maybe it's a estate, and there's 3 brothers and 3 sisters. That's saying that everybody that's signing is everybody that's required to sign. There's no missing signature. There's no party not involved. 26 acknowledges that electronic signatures are authorized by all parties in the transaction. Most people sign via DocuSign or AuthentiSign via email. You can sign a contract on your phone now. So this section right here is required to make that electronic signature legal. So section 27 is the offer deadline. When does the offer expire? So it'll have a date and a time. And ratification and delivery must occur for this to be accepted. And the burden of proof of delivery falls on the other party. So if I'm the buyer's agent and I submit this offer to the listing agent, and the listing agent has their client sign, their seller sign, the listing agent has to send it back to me. I have to receive and have it delivered to me prior to that deadline. Now, if we're past the deadline, it's fine. We can amend it, we can initial, and change that deadline to something after ratification. And it'll just require a couple extra initials. The bottom part of the page is where you sign. That's pretty much it. That's the Richmond real estate purchase contract in a nutshell. I really appreciate you taking the time and watching the video. It's very important that you know what you're signing and what you're getting into, what you're agreeing to. If you have any questions about it, leave me a comment. I'm happy to answer it. Thank you for your time. I appreciate you watching it. Be sure to like this video and subscribe to our channel. I'm going to do more videos in the future about other forms that you'll sign, because this isn't the only one. So I'll see you next time.